Hello, I'm Christina Jimenez,
And I'm Josh Floyd.
and today we are going to talk to you all about mediations. So Floyd, let's start out. What is mediation?
Mediation is an informal settlement process um, where we go through and settle your case rather than going to litigation. It's just an opportunity for the parties to kind of customize their agreement and not have to go to court and battle it out.
Okay, and so how does it work?
So, the way I explain it to my clients is I'll be in one room with you, my client. The other attorney will be in another room with their client. And there's a mediator who's licensed, also a licensed attorney. He goes back and forth and tries to settle the case. And he kind of points out weaknesses, maybe thinks about things that we didn't think about, or, sometimes it's, explaining to clients that what we've been telling them the whole time is correct. It's just the client hearing it from the third person is better.
Okay, very good. And so at the end of a mediation, what is typically going to happen if it is successful, you will sign a document that is called a mediated settlement agreement. And so throughout the probably rest of this video, I'm going to keep saying MSA and Floyd's going to say MSA. And when we're saying that, we're referring to the document that you sign after a successful mediation, which is the MSA or mediated settlement agreement. So like you said, Floyd, we kind of go back and forth. We hopefully come to terms and then we sign the MSA. So tell me typically why you decide to go to mediation or when you decide to go to mediation.
I would say that in most cases we go to mediation. It's really a way to save clients money and the heartache of litigation. Litigation is expensive. It's very stressful. And if you can avoid that, that's always best case scenario, particularly if you have kids. It's best case scenario. And so you go there, you get to customize your agreement where the judge wouldn't be willing to do that. They just kind of go by straight off the code. So I always encourage it. It's a great opportunity for everybody to come together and try to work it all out without having to get the judge involved that knows very little about your case.
And I'll agree. I mean, I say that probably about 90 to 95% of our cases, we go to mediation. And there typically is a cost associated, right? So you have your mediator fees and then you have your attorney's fees to attend mediation. And sometimes that can be a bit overwhelming for clients. But in the grand scheme of things, when we're looking at the costs, like you said, associated with litigation and the stress associated with litigation because of the unknowns, in my opinion, it's money well spent. I have some clients who will come in and say, well, I don't know why we're going to mediation. They are never going to settle. They're never going to agree to this. And to those clients, I'll say, well, listen, we have to try. Because in my experience, there's something about, number one, making the investment to get to mediation. And then secondly, just having to sit down and have another experienced attorney come in and tell you, like, listen, this is why you have these weaknesses in your case and you need to just get this thing behind you. So I'm a huge fan of mediation. I recommend it to most of our clients. I don't know that there's a case within the past year that I haven't recommended mediation. So, kind of talk about how it works. We've already discussed that, I guess, kind of the logistics behind it. Typically when we're deciding to whether or not we should go to mediation, we have a strategic meeting with our clients and we say, this is why we think mediation is going to work for your case and why we think you need to do that. Typically the lawyers, so ourselves and opposing counsel, they're going to we'll agree to a mediator. And if for some reason we can't agree to a mediator, then we have to file a motion with the court and the judge is going to appoint a mediator. I personally never really understood why people object to mediators because you have a decision at the end of the process, right? Are you going to accept the agreement or not? Once we are ordered to go to mediation, we all show up and then we start negotiating. Now, I will say that at our firm, we typically have a pre-mediation meeting with our clients. And so, Floyd, why don't you talk to them about the pre-mediation meeting?
Before I go into that, I want to address the cost factor. Kind of the way I explain it to my clients real quick is, let's just say, for example, it costs $5,000 to go to mediation and $15,000 to try your case, right? Considering the fact that we settle 90% of our cases at mediation, if you look at it just from like a gambling perspective, right? I mean, you have a 90% chance of saving $10,000 and a 10% chance of losing $5,000. And so financially, I think that the risk is worth it. Anything on that before I move on?
I don't think so. No.
All right. So pre-mediation meetings, this is kind of where we get to the nuts and bolts of what we're going to be requesting at mediation. Kind of explain the process and all of that if we haven't already done it. But what we're really looking at in the pre-mediation meeting is making sure that we're on the same page with what you want, right? And what our client wants, what their goals are, what's really important to them, what they're willing to give up on, what they want in return, that kind of thing. Making sure that we have all of our documents in line to establish what we need to establish at mediation, kind of what our first offer is going to be, what our bottom line is. Go through all that, so we're not trying to do that on the day of mediation. There's enough going on at mediation. We'd like to have all of our ducks in a row before we go, and that's when we do that.
So I'll tell all of my clients before we have our pre-mediation to draft what we call, or what I call, a wish list, right? And part of that process for me, at least, is so that I can set reasonable expectations prior to walking into mediation, right? And so sometimes I get a wish list of 50 to 60 different things, and I go in and I tell my client, listen, about 40 of these are just not realistic. And the way that I gauge what is realistic is, what do I believe the court is going to do in this particular situation, right? So, I have 13 years of experience. Floyd has 9 years of experience. A lot of times he and I have powwows about, all right, this is the fact scenario. What do we think judge is going to do in this particular instance, right? And based on all of our experience, all of our past hearings, we say, this is what, if we had to bet, what's going to happen, right? And so based on that, when I get these wish lists, I will say, listen, I understand that this is really what you want, but there's no way that we are ever going to get this from a judge. And so I need you to kind of let that go. Or depending on what it is, I'll tell them, if you really want this thing, you're going to have to give something else up, because the other attorney is typically going to know that whatever it is that you're asking for is not a realistic probability. And therefore, there's going to have to be some trade-offs if you really want that. And so the wish list is there. When we have these discussions, I always ask, what is your walk-away point, right? So what is the one thing, or is there one thing that if you do not get this, that you're just going to have to say, I'm finished and I don't want to negotiate anymore? Because I think most people have that kind of line that it has to be drawn. And so I think that it's important for us as the attorneys to kind of know where we're starting off and where we're going to finish this thing before we walk into mediation. I remember years and years ago when I first started, I would not have necessarily pre-mediation meetings with my clients, and we would kind of go in and we would figure this stuff out as we were going. I know that there are still a lot of attorneys out there that do that. And I think that is so stressful for the attorney. I think it's stressful for the client. I think that you miss things. So typically, before we walk into mediation, and I don't know about you, Floyd, but I'll type out my exhibit to my MSA, and I will just have it all up and ready to go, and I'll work off of that as we're doing our mediation. So that way, I make sure that every little thing that was important to our client, we got it for them.
Yeah, absolutely. Yes, I do the same thing. And the important part is that you may end up being willing to change at mediation based on what they're willing to give, because we didn't anticipate what they would be willing to do. And so a lot of this is, I call it war games, right? So we're trying to guess what the other side will do and how we're going to handle it back and forth. And there's a lot of decisions that are just too difficult to make at mediation, right? With regard to particularly kids, right? And so the pre-mediation meeting gives them an opportunity to think about the things that we've told them that are realistic, and to lower their expectations or whatever, and not being blindsided by that on the day of mediation and being emotional and then having to try to make these decisions that could affect the rest of their life.
That's right. Yeah. So, the other thing that I try to explain to clients, and I had a mediation the other day, and the client was incredibly frustrated because he just thought that the terms, it was about visitation, he thought that the terms of the visitation for a young child, it just wasn't fair, it just wasn't right. And I agreed with him, right? But what I had to look at was, what is this judge going to do if I have to go to court? And unfortunately, compared to what we were being offered and what I thought the judge would do when we walked into court, there was this vast disparity to where, even though our client didn't necessarily like the offer that was being made, it was far better than what I was going to get in court, right? And that is always what the mindset that clients need to have when they're walking in there. Is not what's fair, not what's right, not what I really want. It's what's going to happen when you walk into that courtroom, right? And then I always have to factor in the cost of litigation, right? And so, hypothetically speaking, if we are, fighting for an additional $10,000 to when we go to court, right? That's what we're litigating or arguing over in mediation, and the cost to get to court is $10,000. Then sometimes we may have to say, listen, we understand that you don't like this or that you don't want to do this, but the cost benefit analysis, it just doesn't really make sense to continue to litigate. And obviously, those are sometimes very personal issues. I've had clients who say, listen, I don't care. I want to go to court and I want to fight. And I've had others who just say, yeah, you're right. And I just want to get this done. So anything else on that issue, Floyd?
Nothing else.
So, I guess the next issue is the enforceability of an MSA and why it's important to have an MSA. Floyd, why don't you speak on that?
So, like she said, once you complete mediation successfully, you come to an agreement, you're going to sign an MSA. The MSA is enforceable. It's irrevocable. You can't change your mind, right? Once you sign off on the dotted line there is no buyer's remorse. There's no going back on it. And again, another advantage of the pre-mediation meeting. So you have plenty of time to think about things, because you can't come back the next day and say, oh crap, I forgot ABC, right? It's too late. And so it's enforceable. You can't change it.
Right. And so, there's a lot of times when I'm in mediation, not a lot of times, but there's been occasions where, my client just was very emotional. Think about it. We're ending a marriage and there's, children involved. There's lots of things that are going on. So there's been several times where I've told my client, listen, or told the mediator and opposing counsel, like, hey, we need a day or we need a couple of days before we sign this thing, because I need to make sure that my client is in the right frame of mind before we execute this, right? That doesn't happen often, but I do think that it's important that, we consider that as lawyers before executing an MSA, because like you said, once you sign it, it is binding, it is irrevocable, and there is very few instances where we can get those things set aside. So anything else on mediations, Floyd?
I don't think so. I mean, I just encourage everybody to consider mediation as a process to dispose of your case. I think it's a great opportunity not to have to go in and beat everybody up and spend a bunch of money. The only people that, enjoy litigation are the attorneys, because we make money off of it. Other than that, it's not fun for anybody.
Right. Yeah. And I will say, one of the best things about mediation is the fact that you get to really come to an agreement that works best for you, right? When you go to court, the judge is going to look at the family code. The judge is going to say, listen, these are the presumptions. This is what the code says I have to do. Some courts have very, not rules, but they have, past decisions where we know, listen, if y'all are both fighting over the house, it's going to be sold, right? And if you want to secure that home, then you may be able to give something else when we go to mediation. And so you get to kind of decide, this is what's important to me. I'm willing to give some things up in order to get this thing. And when you go to court, you're probably not going to have that opportunity. So just keep that in mind. And, like always, we always encourage everyone to hire a really good family law attorney when you guys are having to deal with these types of issues, so that you make sure that you're getting, the best guidance possible, the best advice possible, and that you are doing what is best for you and your families.